right, so podcast VIN number 27, you tell me? All right, so welcome to ScottCast, the podcast number 27, and we're very lucky today. You look very relaxed.
I am.
Cool. Kathleen Flammia, who's an estate and trust and elder law, if I'm not mistaken,
Yeah.
yes? So you have numerous degrees and accreditations. And how long have you been doing it now? Because I know you and I have known each other a fairly long time.
Yeah, I've been practicing law since 1989, and I have been in the elder law arena since 2002.
Okay, so just a minute or two.
Yeah.
All right, well, good. Well, my goal today in talking to you was to kind of dispel myths and silly things people think about wills and trusts and elder law and when do we need elder law and how does that pertain to Medicaid and some of the issues people encounter as they age where they might go into care and then they have some assets, but they're trying to protect those assets, which is always way more complicated than I think just hiding it or giving it to an adult child, which is, I hear that all the time. Well, I'll just give it to my kids or I'll just transfer the account. I'm like, I'm pretty sure it's not that simple. So maybe that's a good starting point, is talking about, a lot of times elderly people are trying to protect their assets in the event that they need care, which is obviously costly. So maybe you can talk about Medicare and Medicaid and how they apply to all those kinds of things.
Yeah, sure. So, picking up on what you were asking about, if I'm trying to get qualified to get some government benefits to help pay for long-term care, should I just go ahead and give my children my money, my house, right? The big fat answer is no. And the reason is because before you apply for Medicaid, you need to understand that there's a 5-year look back window. So from the moment that you're applying, they're looking back in time. They're taking like a financial snapshot and that moment of your application, when they receive your application, as to what happened the 5 years before. So if you simply gifted things away and got it out of your name, number one, you could be incurring lots of tax consequences. If you're gifting property, the children are going to lose the step up in basis, meaning they're not going to inherit the real estate at the date of death value.
Right.
So all of these become issues, but most importantly, when you're trying to get qualified for long-term care, there's a presumption that if you gifted anything away or sold something for less than it was worth, then you did it to lower your assets to get qualified for Medicaid. So that's a rebuttable presumption, which can successfully be rebutted if there was an established pattern of gifting over many years. And if you were in good health, and we can prove that by medical records. So the notion of, let me just take what I have and give it to my kids, is a horrible one. Number one, because it could disqualify you. But number two, what if something happens to your kids?
Yeah.
What if they die and that money goes via their estate plan, or they get sued, or they get in a divorce? The money that you think that they're safely holding for you isn't really safe.
Well, and to me, it just, again, falls into that category of people are always looking for the easy way out. And to say, well, this last minute, I'm going to give all this money away. And the government certainly hasn't thought of this. They'll never catch on, right? It's just silly. So what you're saying, which is what I always think ends up being true, is planning in advance, meeting with a financial planner or an estate planning attorney, elder law person like yourself, way before that becomes an issue. I'm not talking about at 25 possibly, but certainly in your 50s is probably a time to start thinking about, how do I prepare for what could happen? Maybe it won't. In 10 years or 15 years or 20 years, establishing patterns. But I'm going to go back to one of the points you made, which I think is interesting, and I hadn't even processed before, the idea that if you gift real estate to your adult child, let's say it's worth $300,000, but you only paid $100,000 for it or whatever, that $200,000, you've lost the ability to step up to the date of death, which means that adult child that did that transaction possibly just cost themselves $50,000, $60,000 in taxes. Is that a
Right.
fair way to put it?
Yes, and we do still have step up in basis, although I know there's talk of that going away.
Right.
But we do still have that, so you do need to take that into consideration in any planning that you're doing.
Yeah, I think that's a good point. I just, again, for me, I hear people say, well, I'll just give that away or I'll just do this. No, they didn't just fall off the turnip truck. They know all the gimmicks people try, and they're likely not to fall for them. So I think establishing that pattern when you're in good health, which was well put, I think is a fair point to make to people, is in addition to doing your financial planning on the stocks and bonds side and all that, there's another side to the equation, especially for families of, considerable means, or at least moderate means, maybe in that $500,000, $1 million and up category. I think that kind of planning is essential. So the other one that I get a lot, I almost had a fist fight with my mother over this, which is weird to say. Not really. She would have won anyway. About the difference between an estate and a will, right? And people think, well, I have a will and that's good enough. And what's the difference? Why would I pay a couple grand to have a trust done when I can get a will done for $300? So can you kind of talk about that maybe from a broad perspective?
Sure. So if you have a will, it's important to define it so people know what it is and how it's used. A will is basically written instructions to the probate court that tells the court, number one, who you want your personal representative to be. Up north, they call that person the executor. So a lot of people move down here and they're still calling it the executor, but we call it the personal representative in Florida.
Okay.
The person who hires the lawyer to administer the estate through probate. Number two, who do you want to inherit from you and how? Now, during that process of probating the will, you have a court involved. You have a judge who administers the will, admits the will to probate, issues letters of administration to the personal representative. The lawyer publishes the notice to creditors telling the world, hey, this person died, did they owe you money? The lawyer has a responsibility of sending known creditors and looking for creditors, sending them an actual notice to creditors by formal notice, not just relying on them seeing it in the newspaper. The creditors has 90 days to file a valid, timely claim, or they're forever barred. They get paid first. If there's not enough money to pay them all, they get paid pro rata, and that's before the beneficiaries see any money. So a will is basically an invitation to file a lawsuit against yourself after you die. And it's exposing the money that you're leaving in your estate to your creditors. Some people feel very strongly about that. I want to make sure that any bill that I incurred when I was alive gets paid. Other people say, well, can I avoid that by listing beneficiaries on my brokerage account, my life insurance, and my retirement account? Because those things that have a joint owner or a named beneficiary, by what we call operation of law, goes directly to those beneficiaries and is not available to your creditors.
Right.
And that's kind of how the trust works. So under the law, when you die, you file a one-page notice of trust. Oh, let me go back to say, the will is a public record. Anybody can go down and read it, so they can know if you disinherited them, and you don't have to leave them a dollar. You just disinherit them for reasons best known to you or best known to them. If you have a trust, it's a private document. So you pass, the lawyer prepares a one-page notice of trust for the trustee to sign. That gets filed in the public records. The only people who are entitled to a copy of the trust are what we call the qualified beneficiaries, the people who are going to inherit under the trust and those that could inherit under the trust. And those are the people that are also entitled to an accounting of how the trustee spends the money. Now, in my experience, if there's no probate opened, I've only seen one creditor, my entire practice, open a probate to get paid from the decedent's trust. Because under the law, the trustee of the trust has to leave those trust funds available for up to 2 years after the decedent dies, unless there's some sort of a probate done, even a summary administration, to allow you to publish a notice to creditors and shorten that time period. So the trust is private. It's not a matter of public record. It passes without court involvement. There's no judge overseeing it, but a lot of people are surprised that they do need really a lawyer to make sure that it's being done right, because the beneficiaries are entitled to certain information. The trustee has to sign an acceptance of trusteeship, file the notice of trustee, get an EIN, and follow the terms of the trust.
So it sounds to me like obviously the trust is the more ironclad, less fussy process in the end. There's still some fuss. There's still some administration by an attorney, especially if you're smart about it, because a lot of times people try to avoid, penny wise and pound foolish, if you will, sometimes with that sort of thing. It's always, I think, helpful to get professional guidance. To me, the trust is just a more ironclad. As you can imagine, 33 years in my business, I've seen people pass with a will and people pass with a trust. And the trust is by far the cleaner, quicker, easier process to go through. As you mentioned, wills are an invitation for trouble, in my opinion. And I've seen beneficiaries go at it. I've seen all kinds of things take place in families, let alone, as you mentioned, creditors and alike. So in your many years of doing this, what would you say are the big mistakes people make? Now, we're not talking about people who are worth billions of dollars, but most of the mass affluent, if you will, people who have net worths of around $1 million to $5 million, let's say. In your experience, what simple things people avoid doing that they should do that would probably save their heirs a lot of grief? What would you say the top 2 or 3 are?
Sitting down with their financial planner and their estate planner.
Well, that's a fantastic answer.
Well, it's the truth. And especially having the financial planner, the estate planner, and the CPA work as a team for that client, that's how they're really going to maximize the benefit to the client. But just having, so many people are just afraid to have a conversation about what happens if I'm alive but incapacitated. We're hopefully ending a pandemic, and it's brought that to mind to a lot of people. Oh my gosh, perhaps I need to look at this. What happens if something happens to me? And when they actually sit down to have the conversation, at least with us in our office, and I'm sure with yours as well, it's really not that scary.
Yeah.
We help them think through some important decisions and make some important decisions. Everybody always thinks estate planning should only happen after you die, but the reality is both you and I know, you have to plan for what happens if you're alive, but you're not competent. How good is your power of attorney? Has it been updated since 2011 when the law changed? If you don't have long-term care insurance, which is something we ask routinely when we're doing even a basic will package, let's make sure your power of attorney has what I call public benefit language, so we can save what you have in a crisis if you don't want to look at doing an irrevocable trust 5 years ahead of when you may need Medicaid.
Right. So to save what you have in a crisis, so talking about long-term care, and I have found insurance is always a difficult conversation. Not always, but oftentimes people have very strong feelings about insurance, which I always find a little humorous, because it's simply a tool. It's a hammer. No, you don't wash a window with it, but yes, you can drive a nail with it. And some people just peel back and don't want anything to do with the conversation. Some people are like, yes, I went through this with my mother or my grandparents, and I definitely want this thing. And there's no absolutes, but protecting one spouse, for example, against the deterioration of assets. So if somebody who's worth $1 million liquid, well, we could see $300,000 or $400,000, $500,000 disappear pretty quickly with no long-term care coverage, which means that the remaining spouse now has $500,000 to produce income to live off of. So again, there are no absolutes in any of this, but I find it, actually, I think it's fantastic that you at least ask the question and bring it up in your consultations. What else do you see people struggling with outside of that?
Who can act for them? I had a client come back to me just today after 11 years and was like, I don't think I want my children acting in these fiduciary positions, because although they get along now, Kathleen, how children can be about money after their parents go. And I said, well, then perhaps we need to look at having some third party act in these fiduciary positions for you. So we have that within families, and then we have that for people who have no family. Right now, I'm actually acting as a personal representative for a gentleman that I met about 17 years ago. It's the only time I agreed to act in this capacity, but he was from England and he had no family here. His wife had just died. All his relatives were in England, and he literally had no one. And I, in a moment of weakness, said, okay, I will do that. Let me tell you, there's a lot of work to act as a personal representative, and I'm finding out firsthand. But trying to find other people, other than me,
Sure.
to act in these roles for people, to make a healthcare decision, to act as a power of attorney, to act as a trustee. That's really important. And then the other thing is, even if they've done their estate plan, they need to review it and make sure that the people that they have in these fiduciary capacities are the ones that they still want, and then the plan still works for them. The plan I did 11 years ago for the gentleman I was speaking to this morning, we funded everything into the family trust because the federal exemption amount was so much lower back then. But now when I'm redoing it, I'm going to fund everything into the marital trust with a disclaimer to the family trust so they can get the step up in basis upon the first spouse's death and then upon the second spouse's death, as long as that remains, around.
Did you get all that,
So,
Ben? Yeah.
So anyway, what I'm saying is things change,
Sure.
and just because you've done your plan doesn't mean you've done your plan. You need to review it in light of changes in the law, changes in the tax law, changes in your family, changes in your situation.
So it's a dynamic situation. So I have two questions that brings to mind. One was you mentioned like the healthcare directives, number one, and number two, how often, again, you could go at any time. I could be run over by a bus tomorrow. We just went through COVID, and hopefully we're on the tail end of that. But how often do you think people should revisit that? Because I know personally I've done it loosely every 5 years or so. What would you recommend?
Yeah, every 3 to 5 years, or if there's a change.
Okay.
There's a death, there's a marriage in the family, there's a health situation, family dynamics have changed for some reason, their money situation has changed.
Mm-hmm.
They received this large inheritance, they've never really had money before, they're not quite sure what to do.
Yeah, and okay. And then in terms of the healthcare directives, is that usually done at the same time as the trusts and or will?
Right. So the basic, let me say the will-based package would be your will, your durable power of attorney, which to me is one of the most important, if not the most important, estate planning document a person can have, because it allows someone outside of guardianship court to handle their finances and sign contracts for them without taking on individual liability for the agent who's acting. The healthcare surrogate, the HIPAA release, the living will, and the declaration of pre-need guardian. So that's the will package. If we do a trust, whether it's a revocable or an irrevocable trust, you're going to have a pour-over will, meaning, hey, I forgot to title something in the name of my trust. It's going to go through probate and be poured over into my trust and be distributed the way my trust says.
Okay.
And then you're going to have all those other documents as well.
Interesting. One of the things that I come across, and I guess I'm just looking for some feedback from you, is a lot of times a client will walk in, or maybe a new client will come in and they'll say, well, I have this and that brokerage account, and I have some money over there, and they're all in my trust, and they'll hand me the statement. And I'll look at the statement, and I'll say, well, you may have a trust, but these accounts are not in the trust. And I think you call it funding the trust in your business. We just would be calling it re-registering in the name of the trust. But a lot of times clients, and sometimes the client will bring something in new that we haven't seen and it's not titled in the trust. So I think it's critical for people to not only get the trust, but recognize the work is not done there. So how do you encourage or...
So we give them funding instructions. We make a list of their assets. We say what has to be put in the trust. They can either engage us to do that funding with them on various levels. It can be as simple as 3 and 6 months from now, we're going to have a sit down and you're going to prove to us what you've got in the trust.
How often do you do that?
Well, my paralegal does it.
Yeah.
But it normally takes about a year for people to properly fund their trust.
Yeah.
A lot of people are, no, I just want to do this myself, or my son-in-law is my financial planner, so he's going to do it. But, we encourage them to make sure that they at least send us the documents, because we want to make sure we send out what we call 6-month follow-up letters. Did you fund the trust? Prove to us that you funded the trust. Because what happens, as you said, is if the trust is not funded, everything goes through probate, and then it goes into the trust. Why?
Right.
I mean, the whole purpose was to have it avoid the trust. So if you're alive but not competent, your successor trustee is going to have an easier time dealing with the banks and the financial institutions, the brokerage houses, in the role of trustee versus in the role as agent under power of attorney.
Yeah.
I am my mom's co-agent, as is my sister, under power of attorney, and I moved her up here 4 years ago. And I went to the bank on Friday for the personal representative case that I'm acting in, but also for her, she had a 62-cent CD that I could not get closed, okay? It took the guy, because he had already sent the power of attorney to legal, it was already approved, he had to attach it to the CD account, blah, blah, blah. It took him a half hour to do that over a 62-cent CD, but with my OCD mind, it was driving me nuts that the 62-cent CD was hanging out there, and I was going to have to somehow deal with it when Mom passed. I'm like, no.
So we spent a few $100s worth of people's time to get rid of 62 cents.
Yes, but it was my time, and I don't get paid.
Right. But normally you would, so you're not getting that time back. Well, I think one of the reasons I wanted to talk to you is just to kind of get out there, just to inspire people to say, oh, yeah, people that are going to watch this, whether they're my clients or otherwise, whether they're your clients, whoever they are, I would like to this is kind of a reminder. I want to do this every year to say, listen, don't forget this is a fluid situation, that things change. You got some money, you bought a piece of real estate, you had a change in marriage, and that's another one, a lot of times changes, and this isn't exactly in your realm, but it kind of is in beneficiary changes even. Just
Yes.
something as simple as you got a divorce, but your beneficiary is still your ex-wife. I joke, but I've seen it happen where the current wife or husband calls up and says, yeah, so-and-so passed, what do I do to get my money? And then I look at the document and I'm like, ooh, this is going to be a tough conversation because you're not getting the money. The ex is getting the money. So just be diligent in all of these things. And I think like a lot of things, and I think this is when you came out of the gates with this, you said, this requires effort. And people are always looking for the easy way. Well, it will only cost $300 or $400 or whatever the number is, so I'll do that. Well, that $300 or $400 might cost your heirs tens, if not hundreds of thousands of dollars if you don't do all the documentation right. You aren't thoughtful about planning for that potential of being in care, which I think is much higher than it used to be with everybody living longer. The potential for you to require long-term care and for that to deplete assets to the tune of, I've seen as high as $11,000 or $12,000 a month sometimes.
Oh, for sure. 15 even.
Yeah, I just think that it's so critical for the mass affluent. I keep using that term because I think it's probably the most accurate one in this description. Because if you're a billionaire, you probably don't have these issues about long-term care. But if you're the mass affluent, somebody who's worked their entire life diligently, carefully, disciplined saving, all the ways, the old-fashioned ways to save money and get to wealth, you're the one most likely to pay the price in the end if you don't do this planning. Is there any one thing you would recommend to people before we call it a day?
If you do nothing else, get a well-written power of attorney with public benefit language in it. If you do nothing else, because it will avoid a guardianship, and that is a proceeding through the probate court where you're determined to be either totally or partially incapacitated. Your rights are taken away and given to either a family member who's acting as a guardian or a professional guardian, and a lot of money will then be spent on attorney's fees and guardian fees. And in order for that guardian to act over certain actions, they have to have a court order, which means more attorney's fees. Mm-hmm. And you're deemed incompetent. So that's a loss of dignity that no one wants.
Yeah. Well, this was awesome. Thank you very much.
Thank you for having me, Scott.
Yeah, everybody, Kathleen Flammia. I've known you for a long time, and you have a sterling reputation, which is why you're sitting here. So we appreciate you making the trek out to Sanford.
My pleasure.
To come see Vin and I.
My pleasure.
I guess that's it for ScottCast, the podcast, episode 27.